Hello and welcome to the DFW Divorce Insider Podcast, answering all of the questions you didn't know you had about family law. I'm your host, Matthew Eitzen, and I'm here again with name partner here at Duffy and Eitzen, my mother, Melinda Eitzen. How are you, Mom?
I'm great. Glad to be here, Matthew.
Very excited to have you back. Our topic for today is the big L word, litigation. Perhaps the most daunting aspect of family law, at least for the clients, and the subject of many Hollywood films. The divorce trial, common dramatic premise. And of course, could you talk just a little bit about your personal experience with litigation?
Yes, so I've litigated for 26 years, and although you're right, it is daunting for people. We will do our best. We do our best to make it not as scary. And I've litigated all over the DFW area and in some far-reaching counties for a variety of strange reasons. But, but I've been doing it a long time.
No. I think we should just sort of walk through some of the common questions that people have, sort of common concerns, things that come up a lot. And one pretty obvious one that would suggest itself is the question of mental illness, and then probably could be conjoined to mental illness, the issue of substance abuse, sort of things that cause behavioral problems which can lead to divorce or can complicate a divorce.
Yes, that's a good question. So how do judges deal with that is the question.
Yes, is the question.
With bad behavior in the area of mental illness and substance abuse, and I guess you could say substance abuse is a type of mental illness in a way, judges will forgive anything if people take personal responsibility for their actions and take positive steps to improve. So it's better actually to say, I have a problem. Here's what my problem is. I've gone to this counselor. I've gotten on this medication. I'm going to AA or whatever the steps would be. What they don't like is when somebody has a problem and they're in denial and they're not taking positive steps. And where all of this is most relevant is if there's children involved. No one cares as much what you do as an adult if you don't have children, right? So great, get divorced. But if you have children and you want to see them on a regular basis in a normal way, you have to take care of your mental illness and your substance abuse. And I think the myth out there is that people should hide the fact that they have a problem and not be taking medication. And oh no, the judge will think I'm crazy if I'm taking medication. But that's absolutely the opposite. The opposite is true. Judges like the fact that you're taking medication if you need to be taking medication. And it's not a horrible sign. A lot of Americans are taking medications. It does not mean you're crazy. It means that you've recognized you have a chemical imbalance, you need a little assistance.
There we go. That's very good advice. And do you have an example that you could give of sort of a client doing this well versus a client not living up to that advice?
Okay, that's a good question too. So one example of doing it well is sometimes people will come into court and they'll testify, well, I'm going to AA. And then the judge will say, or one of the lawyers will say, do you have a sponsor? And if they're really going to AA and they're serious about it, they should have a sponsor. So the answer to that is telling. And then they'll ask, well, what step are you working on? And AA is a 12-step program. They have 12 steps, so they should always be working on a step, and they work the steps over and over. You don't just finish the steps. So if they don't know what step they're working on, that would be a sign to the judge that they're not really going to AA and participating heavily. So there are some ways like that example that a judge can tell if they are seriously taking care of their matter. And everybody doesn't have to go to AA. That's just an example. It works great for some people, and it's free, which is a wonderful quality, but it isn't for everyone. So it's not that you have to go to AA. You just have to be doing something positive and constructive to deal with either your mental health disorder or your substance abuse problem, if you have one.
Okay, there we go. I think that was pretty comprehensive. So the next obvious issue that suggests itself when talking about divorce is adultery, which I think is I think can be very fraught for people. And so could you talk a little bit about how judges usually approach that? And could you also talk a little bit about the concept of fault or no fault divorce? Because I know, or at least I believe, that before no fault divorce became a sort of a nationwide thing, adultery was one of the reasons that someone could demand a divorce. Is that right?
Yes, and historically, way back, people had to have a fault reason in order to get divorced.
Mm-hmm.
Now we don't. You can just get divorced because you want one. You don't have to have a reason.
Mm-hmm.
And that's a wonderful thing, that you do not have to go prove that they did something bad to you. But I will say adultery is a very common aspect in a lot of cases that we see. I would say most cases, unfortunately, have an element of adultery. And I believe the reason for that is it's not the cause of the breakup of the marriage, it's a symptom of a failed marriage.
Mm-hmm.
So the marriage has already failed, or they wouldn't have put their glorious, wonderful marriage at risk by committing adultery. People who are happy do not commit adultery, in other words. Mm-hmm. It's people who are unhappy that are susceptible to the temptations of adultery. And because it is so common, and because I think the judiciary also views it as a symptom of a failed marriage, and they realize that marriage is much more complicated than pointing at one bad act by one person, mm-hmm. I don't think that judges are shocked and appalled as the person who was cheated on is. Mm-hmm. And that is disappointing to the person who was cheated on, because of course, it's their personal life. They are mm-hmm. shocked and appalled, and they think everybody else should be also. But the judges I don't want to say that they don't care about adultery. They just view it in a more complex setting, mm-hmm. and not as the only reason that the marriage failed. And I would say that they don't, on the whole, penalize people for committing adultery. Now, having said that, it is still a grounds for divorce. You can prove it up and say, I want to get divorced on the grounds of adultery. Usually there's no point in that, but you can. Mm-hmm. But one reason, I will say two areas where it could be relevant. One, if you have children under 18 and you're fighting over the children and the parenting schedule, if your adultery is interfering with your parenting, an example would be when it's your parenting time, instead of parenting, you're dropping off your kids with a neighbor all the time to go be with your affair partner. Now the adultery has suddenly become of interest to everyone. Another example of an area where adultery would be relevant, or a portion of it, is if you were spending a bunch of money on your affair partner that was community funds. Everybody cares about that. And the court will count that money back into the estate as if you hadn't spent it, and penalize people in that way financially. Count that money back in. So what I mean by that, counting the money back in, is let's say that somebody spent $10,000 on their affair partner. The judge could say, well, I'm going to pretend like you still have $10,000 and you have it in a savings account, and I'm going to award that to you, affair person. And I'm going to give your spouse a real $10,000 out of your estate to offset it. So that's where it could be relevant. Adultery is on the list of reasons that a court could order a disproportionate division of the estate, meaning we're a community property state and the court starts with a 50-50 idea of the division of the estate. but there's a list of reasons they could vary from that. So they don't have to divide your estate equally. They could give one person 55% of the estate or 60% of the estate. And adultery is on the list of reasons that the court could consider. But in my experience, it's really not the reason that a court would give a disproportionate division. A much more common reason would be if one person has a much higher earning capability than the other. So if that's the case, maybe you had a stay-at-home husband or wife who didn't work for 20 years or 40 years, and their spouse was a doctor, and the spouse made a bunch of money and is still going to make a bunch of money. That spouse who did not make any money during the marriage, who didn't work, they might get more than 50% of the estate because of that fact that they need a little more money because they're not going to make as much money in the future.
Mm-hmm. And that tends to be of much more importance to judges than adultery does, in your experience.
That's exactly right.
Great. And I think that's a pretty good segue into the sort of second half of this episode, where we're going to talk about the money stuff, all of the different money things. And one of the first sort of components of the money side, and a term that I think a lot of people are familiar with, even if a lot of people I think don't know exactly what it means, is alimony. Can you talk a little bit about alimony, just what it is, and then we'll move on from there.
So alimony is something that the court has the power to award in very limited circumstances to one of the spouses post-divorce. And it would be typically a payment by one person to the other post-divorce on a monthly basis. So for example, somebody might be ordered to pay $3,000 a month to their ex-husband or wife for a year or 3 years or something like that.
Mm-hmm. How is the rate determined typically? Is there a set formula? Is it just sort of judge to judge, case to case?
Well, the truth is our alimony laws are very narrow and very limited, and very few people qualify for alimony under the law.
Mm-hmm.
So, having said that, there is a formulaic approach in the family code for those people who do qualify. And it's really not a formula in the sense of it necessarily gives us the number, but it gives us caps, that it wouldn't be more than a certain number. And that formula is based on years of marriage, how long they were married
Mm-hmm.
before. But having said that, I've been doing this 26 years, and I've had very, very few, like on one hand, number of cases that would actually qualify under the law. Mm-hmm. I have had more than a handful of cases have alimony in their final agreement, but that has been by agreement, not mm-hmm. by court order. So judges don't order it very often because we have such horrible alimony laws. Now, mm-hmm. having said that, we talked about before that one way the judge can make up for that is by this disproportionate division of the estate. Mm-hmm. So if they can't under the law give someone, in my prior example, who hasn't worked for a long time, alimony, they at least can give them more than half of the marital estate.
Mm-hmm. Okay. And does your employment status matter at all for alimony considerations?
Sorry, go ahead.
No. I was going to say, because one thing that occurred to me is someone might sort of instinctively say, oh, well, I should not get a job or quit my job because then I will, be a more credible recipient of alimony, if that makes sense.
Yeah, that's a common myth or misunderstanding that people should try not to get employment. And when people come to me who are pursuing a divorce, or the other side is pursuing the divorce and they have to get a divorce, because if you want one, you get one in Texas. The first thing I tell them is go get a job, because the chance of them getting alimony is so low, and not seeking employment is not going to help that chance. Mm-hmm. They would be much better off getting a job and making money in the long term of their life, because mm-hmm. even if they qualify for alimony, it's going to be for a very short period of time. So mm-hmm. they definitely should be thinking about, how can I make money?
And if there are children involved, I don't think it's going to look very good to the judge if one of the parents is unemployed. I would assume.
Yeah, you need to be able to support your children. I mean, of course, the other side is going to be ordered to pay some amount of child support also, probably, but child support is not meant to meet all of the children's needs. It's supposed to meet some of them, and the parent who's receiving child support is expected to also provide some money towards their needs.
And that, I think, is a good segue to another topic, the question of child support. And could you first talk about when is child support awarded and why and how? And then could you talk about what mechanisms are in place to enforce payment of both the paying of child support and to ensure that the parent receiving the child support is not misappropriating those funds?
So people can do anything they want by agreement on child support, but we're going to assume for purposes of this answer that we're talking about in a litigated situation where the judge is ruling. Judges under the family code are presumed to order one person to pay child support to the other, and they're typically ordering the person who has the children less time to pay child support to the person who has the children more time. And child support is a very specific formula in the family code, and it is all connected to the payors, the person paying, how much money they make. It has nothing, the formula does not consider at all how much money the person receiving child support makes. Now, that's not true in other states, and the child support formula in Texas is different than child support formulas in other states. So that's just how our legislature decided to do it. But in our state, if you have one child, you pay 20% of your net income a month. For 2 children, 25%. For 3 children, 30%. For 4 children, 35%. You get the idea. But there's a cap. So if the payor makes more than approximately $9,200 net a month, they only pay 20%, 25 on 30, so on, up to that 9,200. So if they make $1 million a month or 9,200 a month, they only pay that percentage of 9,200. It caps out is what we call it. And that cap increases every 6 years. There is also a little modification to the guidelines if you have children besides the children before the court. So if somebody had a child with from a previous relationship that they're financially responsible for, then they get a little break on this child support formula.
Got it. And then what enforcement mechanisms are in place to both make sure that the payor is paying, and that also that the payee or the receiver is spending that money on the children?
So child support is the most enforceable order of the court. And that has been very important to the legislature to make sure that is true. So typically child support, because it's very enforceable, it needs to be crystal clear what you're supposed to do. So typically the order will say the date that child support is due, the amount, it's usually due monthly, and the mechanism for payment. And typically people pay through Texas has set up an avenue for people to pay through. And so typically the government is monitoring this. It's paid through the government then to the person. So they know if you're paying or not. And the Attorney General keeps a listing of how each person's doing, like have they paid on time or not. And they even have penalties and interest accrue on their own record if somebody doesn't pay timely. So if somebody is not paying like they should be, then the person who's supposed to be receiving the child support can for free go to the Attorney General and they will enforce the order for free and seek that child support. And child support, the government has a lot of power to enforce it. The judge does. So they can put people in jail for not paying their child support, and they will. maybe not on the first offense, but they're not hesitant to do it. I've seen plenty of people be ordered to jail for not paying child support, and they suddenly find that money. They can also do things like attach your refund to your taxes.
Mm.
So you get your tax refund and it goes, instead of to you because you have an outstanding child support, it goes to your ex-spouse. And then they can go so far as to affect licenses. So, for example, I have a license to practice law. They could interfere with my license if I wasn't paying my child support, if I owed it.
Mm-hmm.
So there's a lot of power. It's the most powerful thing. So people should not hesitate to seek enforcement of their child support if they're not getting it. And one thing I think you asked was, is there any monitoring on how people spend it?
Mm-hmm.
So there's not. The person who receives child support is free to spend it in any way they want. And it's assumed that they have the best interests of their children and that they are going to supply appropriate housing and shelter and clothing and electricity and, lunch and all of the things your kids need. It's assumed that they will do that. But that is aggravating to people, because sometimes they think, oh, she's spending my child support on a Cadillac. And what I always say to those people is, well, are your children being fed? Are your children being clothed? If all the appropriate things are happening, then no, she's not, or he's not. They're spending it on your child. It doesn't matter. She must have other monies because child support's not enough to do all those things and buy a Cadillac.
Okay. Well, those are all of the questions I have. Do you have any last thoughts, pieces of advice, miscellaneous stories about litigation that you want to add in here at the end?
Yeah, I'd just like to say another thing that people ask a lot is, can I get him or her to pay my attorney's fees? Will the judge make them pay my fees? And the truth is, judges are not, they don't commonly order people to pay attorney's fees. In a divorce in a community property state, you're both going to use your community property to pay for your divorce. So it doesn't even make sense in a divorce when they have community property. But in other actions that occur within a divorce or modification, which is post-divorce, people always say, well, will they make him pay my fees? I shouldn't have to be dealing with him in this way, or he's horrible or she's horrible, and please have the judge order them to pay my fees. And it's just so sad because they seldom do. Every once in a while, I have had a judge order someone to pay attorney's fees, but it is the opposite of what I just described with child support. They're not going to put them in jail for not paying it. It's like a debt, any other debt. So even if the judge does order them to pay it, it's very hard to enforce that if they don't have any way to pay it. If they're judgment proof is a way to say it. The old saying, you can't get blood out of a turnip. Well, that's the situation. If they don't have any money or any assets, then it's hard to make them pay it. So that's disappointing, but true. Assume if you're in litigation, you're probably going to have to pay your own attorney's fees.
I think that's very good advice. Well, that is it for us here at the DFW Divorce Insider Podcast. Thank you all so much for listening. Please remember to subscribe so that you'll get every episode right when it comes out. And if you're looking for family law representation in the DFW area, or if you just want to learn more about today's topic, please check us out at www.duffyandeitzen.com, or just type Duffy and Eitzen into Google. That's Duffy spelled D-U-F-F-E-E and Eitzen spelled E-I-T-Z-E-N. You can also give us a call at 214-416-9010. Thank you so much for listening. I've been Matthew Eitzen.
I'm Melinda Eitzen.
And this has been the DFW Divorce Insider Podcast. Y'all take care now.